Hello, I'm Marites Vitug. Welcome to Rappler Talk. We're here at the Philippine Supreme Court to interview Senior Associate Justice Antonio Carpio, who is due to retire on October 26th. And I think this will be one of his last interviews as an active member of the court. Thank you, Justice Carpio, for joining us. So we'll break the interview into two parts. First is your thoughts on the Supreme Court, and second on your advocacy on asserting sovereign rights in the West Philippine Sea. So first, you've been on the court for 18 years, and you've witnessed at least three historic moments: the attempt to impeach Chief Justice Davide, the impeachment of Renato Corona, and then the ouster of Maria Lourdes Sereno. So how have these changed the court?
Well, the court, I think, has become more careful because of these developments. Mm-hmm. But we continue to do our job, and of course, there are justices who maintain fiercely their independence, and what happened will not affect them, because if they think what they're doing is correct, they will just continue to do it. And the attempted impeachment of Chief Justice Davide, the impeachment of C.J. Corona, and the co-warrant to ouster of C.J. Sereno, I think they are part of the development of our political system and our constitutional law. We have a long way to go because as a nation, we haven't existed that long, really. So we have to learn lessons from all of this. And one lesson that we should learn is that the court should remain independent, and it should fiercely protect its independence, and the public should help the court protect its independence.
How can the public help the court retain its independence?
Well, because the court cannot on its own go out and defend itself publicly. It's the duty of the public, the bar, the citizens to say what they want to protect the court, if they want, if they believe in the court, if they want to believe in judicial independence.
So it's to speak up and to maybe be critical of certain decisions if they are seen as being subservient to the executive department?
Yes, like for example, in the attempted impeachment of C.J. Davide, I think the people rallied behind the Chief Justice Davide and the court. And if, for example, the court comes out with decisions that on the whole will not be acceptable to the people, then there are mechanisms. There are lawyers who can write criticism or critique on these decisions. There are the faculties of the law schools that should also be writing critiques on our decision. And I think we will welcome criticism from the faculties of law schools.
This is an issue I'm sure you've been asked several times, but I don't know if you've spoken about it publicly. You failed to make it as Chief Justice twice when you participated in the application process, and once when you refused to be part of it during the time of President Arroyo. So how do you feel about not having been Chief Justice?
Well, of course, I respect the Constitution, and under the Constitution, it's the prerogative of the President to appoint the Chief Justice and the members of the Supreme Court. I was part of the group that vetted appointments to the Supreme Court during the time of President Ramos, and I understand thoroughly the process. It's up to the President, really, and you just have to take it as it is, because that's how the Constitution is structured.
So, but choosing a very junior justice or not following the hierarchy, does it upset the institution?
Well, that's exactly what happened during the appointment of C.J. Sereno. It's like, for example, in the military, under the Constitution, the President can appoint as Chief of Staff from the rank of Colonel up. So a colonel can be appointed by the president as chief of staff. But of course, you would know what will happen there. If you make a colonel the chief of staff, he will be the superior of 4-star generals or 3-star generals. So you just have to look at it from the organizational point of view, whether it's proper to put a junior over everybody else. You have that power, but it doesn't mean that you should exercise it regardless. So it's really up to the president to take into account all of this. And what happened in the case of C.J. Serena would form part of the experience of the nation. And that's a lesson also to future presidents.
And we've had experiences of having short-term Chief Justices. Chief Justice Panganiban, less than a year. Chief Justice Bersamin, less than a year. Chief Justice De Castro, only a few months. What do these short-term appointments do to the institution?
Well, as long as the members of the court have a fixed vision of where the court is going, I don't think short-term appointments of 6 months or more will affect the direction of the court, because the procedures in the court are laid out and they are carried out over a long period of time. And of course, since everyone in the court is an independent entity, I mean, we can vote the way we want to vote, the Chief Justice really cannot control how the others will vote. He will be outvoted. He can be outvoted by the majority. He can even be ousted by the majority. So the Chief Justice, even if he stays for a short period, I don't think that will affect the business of the court. But of course, long-term reforms in the court require continuity to be instituted in a very stable manner. So it will help if the Chief Justice will stay longer.
When you were acting Chief Justice, I think you have earned the title of being the longest acting Chief Justice. Did you institute any reforms, or you were just a placeholder?
No, when I was acting after the impeachment of C.J. Corona, I proposed the Judicial Affidavit rule. That means during trial, instead of direct examination, you can submit judicial affidavits to take the place of direct examination. There will still be cross-examination, but the result of that is that it cut down trial time by at least 50%. They say even 60 to 70%. And that's huge. And even when I was just a junior associate justice, I did my part in introducing reforms. I set up the e-library within 2 or 3 years that I joined the court. And I think that has helped a lot in terms of research by trial court judges.
Talking about being fiercely independent, I think you've kept that value. How does a justice how does he or she protect his or her independence on the court? Because we're seeing that a number of justices appear to be still loyal to the appointing power. I will not name names.
Well, it's not easy, but it's not also difficult. If from the very start you take that position, they will respect you for that. But if you play balls, then they know that you can be persuaded, you can be swayed. So better just to stick to a position which you deem is correct, regardless, and they will respect you for that. Everybody will respect you for that.
So during the time of President Arroyo, President Aquino, and has anyone from Malacanang, approached you to suggest the way you should decide a case?
Well, fortunately none, because early on I already said that I will just decide a case the way I see it.
So maybe a word of advice to those aspiring to join the court. There will be a number of vacancies. What lessons maybe can you share with them, or what is the most important quality they should have?
Well, I think the most important quality is independence, because without independence, really, you cannot be an impartial judge. And a lot of people are brilliant, but it's difficult to be independent under our society. So that you have to strive to be independent. But if you show that you are independent, they will respect you for that over time.
Why is it difficult to be independent? I mean, journalists also try to be independent.
Well, because we are, we are very sociable, and we want to. It's difficult to say yes to friends. So, especially in the court, I think we should cultivate a code of independence, a culture of independence.
So this doesn't clash with collegiality on the court. You know, you talked about that some time ago.
Well,
yeah?
collegiality refers to respect for the opinions of others in the court, because in the court, one justice may be your ally in one case, in the sense that you have the same view, and another justice has the opposite position. But that justice who has the opposite position might be your ally in another
next
case. And the justice who's your ally in this case might be on the opposite side. So, you cannot take things personally here, because your colleague who will be supporting you in this case will be against you in another case. So you just have to take each case separately, and there's nothing personal about this. You just decide it the way you read it in the Constitution and in the law.
So but are you able to develop friends on the court with this kind of,
Yes,
tension?
over time, you will learn to appreciate each other's strength and each other's respect for you, respect for each other, and that's why we remain friends. Even with some justices with whom I disagreed, in many cases, we remain good friends.
In a speech you gave before the Ateneo College of Law, commencement speech, you talked about the gap between rule of law and rule of justice. And how does the Supreme Court close this gap? What can the Supreme Court do? Aren't you frustrated that there is a gap between these two ideals?
Well, if there is a gap, we try to close it through rules of equity, because we are also a court of equity. In other words, we will dispense fairness and justice, even if there is no express provision of law. But it's only up to a certain point, because equity must follow the law. In other words, as long as we can justify it under a provision of law. But if there is no law at all, we just have to go to the legislature to enact the law, because the principle is equity follows the law. So there must be a law on which we will anchor equity.
I see.
So a lot of laws may be acceptable or perfect even when it was approved. But over time there are changes, and the law becomes inadequate, or there are new developments that the law has not anticipated, and that's where the gaps arise. And we try to close that through the rule of equity, but if it cannot be closed through the rule of equity, we have to turn it over to the Congress to address that issue.
And so you you ask Congress, or you point
Yes.
out to Congress that there is a deficiency?
Yes, we did that in several cases already. We told Congress that the penalty is too harsh, but we cannot do anything. We have to impose it, but we want you to review the penalty.
Now, let's go to the issue, Justice, of leadership on the court. As we all know, these are difficult times. I mean, in terms of rule of law, there is a decline or maybe erosion of rule of law. What kind of leadership is needed during this time when rule of law is being challenged?
Well, the members of the court will look up to someone who is unwavering in adherence to the rule of law. I mean, it will take time, but the other members will see that this particular justice has been very consistent, and that's when you earn the respect of the other justices. So if you are consistently defending the Constitution, consistently applying the law, then you earn the respect of everybody.
Justice, how have your 18 years on the court maybe changed you as a citizen or as a person?
Well, I've learned to pursue advocacies with more dedication because if you want your advocacy to bear fruit, you have to press on and continue despite all the odds. And even if at first it looks like an unreachable star, you just have to do what you think should be done. Like my advocacy in the West Philippine Sea, it looked like a shot in the moonshot. But I think I realized that there was no other way. We have to go through it. So it taught me perseverance. And it taught me that you should stick to your principles, and people will respect you for that, and they will follow you if you show them the way.
Yes, you've been very public on that issue, and some said that you have already crossed the boundaries outside the Supreme Court, that you have influenced the executive department.
Well, when I went on a world lecture tour to convince other governments to support our position, it was with the approval of the court. I asked the Bank for approval. I said that the Secretary Albert Del Rosario invited me to conduct a lecture tour all over the world to support the Philippine position, and the Bank gave me a permission to proceed, because at that time I said I did not have any backlog anyway, so I can do this thing. And I've always asked for permission every time I went abroad. And secondly, our adversary here is China, because China is claiming our territory and maritime zones. And China will never submit to the jurisdiction of the court. So there will never be an instance where this Supreme Court will be deciding a case between the Philippines and China, because China will never submit itself. So there will be no conflict of interest, because we will never decide that case. In fact, China refuses to even recognize the arbitral tribunal at The Hague, despite being a member of UNCLOS. And third, I think it's the duty of every citizen to defend the country in the best way he can. And because I have studied this issue when I was a ponente of the case, the baselines law, I saw that there was an opening to question China's 9-dash line legally. And because it was a legal approach, I felt that I had the competence to convince the government to do it, and that's why I did it. Because everybody should defend the Philippine territory and maritime zones. There's no exception.
Even if the president, criticizes you or is angry at you, that's not an obstacle.
Well, it comes with the territory. You're trying to convince other people who don't see it your way. Of course, there will be a reaction, so you have to engage them in a discussion. And when I first came out with this proposal in 2011, that we should bring China to an UNCLOS tribunal, people were saying, "Are you crazy? China has not done anything against us." But eventually, when China seized Scarborough Shoal, they realized that it had to be done. There was no other way. We had no military capability to defend the Scarborough Shoal. Our only defense was a legal defense to bring China to a tribunal.
Yes, speaking of Scarborough Shoal, we can look at Vietnam now, and something similar is happening. Chinese incursion into Vanguard Bank, harassing their oil exploration. So the Philippines and Vietnam have a strategic partnership. Are we helping Vietnam in any way, or what should we do to help Vietnam?
Well, we have a strategic partnership with Vietnam, but it's not a military alliance. So we help each other economically, in trade, we exchange information, but when it comes to defense, it's outside that strategic alliance. But we have a common adversary here,
Yes.
China, because China encroaches on the Vietnamese EEZ and our EEZ also. And I think Vietnam is looking at what is happening now in Reed Bank, because if we can come to an agreement with China on Reed Bank, that's the same formula that China will offer Vietnam. And I think, so they're looking carefully what we're doing now.
And this is the MOU is supposed to be finalized in November, Justice, between Manila and Beijing, right?
Yes, well, the MOU, there's a statement there that it should be implemented by November of this year. So we have the MOU last November. Then we had the terms of reference when President Duterte visited Beijing recently, and they exchanged also the names for the members of the steering committee. So I understand they will now appoint members of the working group, SINUC, the state enterprise that will partner with Forum Energy. So if this can be done, this will be the template or the formula for a peaceful solution of the South China Sea dispute, because if we accept this, it's acceptable to us, and probably it will be acceptable also to Vietnam, Malaysia, Brunei, and Indonesia. And then we have found the formula to settle peacefully the maritime dispute, at least, not the territorial dispute that will continue.
The Department of Energy came up with a position saying that Congress has to enact a law for Manila, the Philippines and China to enter into a joint exploration. The only way now is through a service contract, anyway, which the MOU provides.
Yeah, the only way now is really through the service contract, and that's why the MOU provides for the service contract, the TOR provides for the service contract, and I've been saying we should go through the service contract approach.
So what does Congress have to do? Does it need to enact a law for a joint exploration of oil and gas?
Well, I don't think there's a need unless they want to change the 60-40, because that's only in the law. It can be 50-50, the sharing. But I think the 60-40 is acceptable already to China, so why do we want it changed? So I think the legal mechanism is already in place. All we have to do is to implement now the MOU and the TOR.
So we don't call, reporters should not call it a joint exploration, just call it a service contract?
Well, we should not call it joint development. It can be a joint exploration, but the proper term is a service contract.
Okay. And during Duterte's visit to Moscow, he invited Rosneft, this Russian energy firm, to explore here in the Philippines. Is this a welcome move?
Yes, I would welcome the participation of Rosneft. It's a state-owned enterprise of Russia. It's the biggest oil and gas company, exploration company in Russia. Because we should be spreading our contracts, service contracts. We should have one with, maybe several with China, some with Western countries, and including Russia.
So if the Philippines and China finalize this MOU in November, then as you said, it can be a template, and this can be used also with other countries outside China, right?
Yeah, Vietnam can also. I've talked to the Vietnamese, and they say as long as they do not give up sovereign rights, they're willing to enter into similar arrangement.
How about Malaysia? Recently, Mahathir apparently softened his reaction towards China. In fact, Duterte calls him an ally. What is the impact of Mahathir's response to China?
Well, you know, Mahathir is a very shrewd politician. When he assumed the prime ministership again,
Yes.
after his recent re-election, he was very hard on China. I want to renegotiate all of these contracts, and he was able to get a good price. He was able to bring down the cost of all of those contracts. Now that he has brought it down, he's now saying China is my friend.
Yes.
But if you look at what's happening in Malaysia, they have been very consistent in filing protests, diplomatic protests. They don't publicize it. Every time there's an incursion by China, they file a diplomatic protest. They don't announce it, but they have been very consistent. And they have a dispute right now over Lucunya Shoal.
Yes.
It's very near the coast of Sabah. It's about 54 nautical miles, and China has seized that in 2013. And so what Malaysia has done is to send a Coast Guard there to watch the Chinese Coast Guard, but they are very quiet about it. But they're eyeball to eyeball, but they're not talking about it. It's just like Vietnam, but they don't publicize it. So Malaysia takes a very firm hand in defending its maritime zone, but they publicly they don't attack China with statements, but they are very firm on the ground.
Just two final questions. The Supreme Court has not decided yet on the JMSU, or Joint Marine Seismic Undertaking case. It has been filed maybe 10 years ago. I know you're leaving the court, but what should we expect? Because this is important in the light of events that are happening.
Well, unfortunately, it has not been decided, and I really cannot talk about it. But it helped also that it was not decided when the arbitration was going on, because it could have complicated our case. Because in that JMSU, we allowed China to explore,
Yes.
and that could have been taken as a concession. But fortunately, it was not brought up, and we did not disturb the arbitration by deciding it. But I think it's time that it should be decided already.
What are your plans after leaving the court? Are you ready to share with the public?
Well, I plan to continue with my advocacy on the West Philippine Sea, and that will be my main work. I'll spend most of my time there. I will not go to private practice anymore. I'll probably teach one subject every semester. But it will be mainly on the West Philippine Sea.
So this is through a think tank?
Well, I will try to gather friends who have the same idea as me. Maybe from there we can decide whether we will formalize our group into a think tank or just continue as a loose group.
So one final question, Justice. How are you feeling now that you're leaving the court? Are you nostalgic, sentimental, or happy?
Well, I feel it's very liberating because I don't have to read stacks of pleadings every day. And in fact, my last session was last Wednesday, and the night before I said, I'll have to finish this because it's the last time I will be reading all these pleadings.
So thank you very much, Justice Carpio, and to our listeners and viewers. Thank you for joining us, and we will keep in touch and keep watching Justice Carpio in his new phase, his advocacy of asserting Philippine sovereign rights over the West Philippine Sea. Thank you.
Thank you.
Thank you.